Hello, am I audible now?
Yes, sir, you're audible.
Okay, perfect. Hi team, how are you doing? How is everyone? Happy Sunday. Thumbs up, something, reaction. Come on. Okay, perfect. So did you guys have so before we begin, did you guys get a chance to go through that exercise, small exercise that I gave you yesterday? Did you guys take a look at it? Please unmute guys. It's very helpful if we can have an interactive session. So if you guys were able to go through it, it is nice. If you guys were able to do it, we can discuss. If not, also it's fine. But I would like to have a response on it. Anyone, someone, guys?
Sir, I wasn't able to go through it.
Yeah, that's fine. No issues. Anyone else? Just a small response would be nice. You can even put it on the chat also if you can't unmute. Okay, fine. Then I'll share my screen. Okay, no issues. One second. Okay. Sir, I can't understand it properly, so no problem. That's not an issue. Okay, so if you guys remember, I told you guys about some of the documents that some of the commercial documents that I draft on a regular basis, and I said that we'll discuss them one by one. So I have few of the templates that I normally use. These are took it out from the internet because I can't show you the templates that I personally use because they are the proprietary property of my company. So I am not allowed to share them, but these are the drafts or the templates that I saw from the internet, which is very similar to the actual drafting that we do. So can we start? Thumbs up. Thumbs up. Okay. So let's begin with NDA, a non-disclosure agreement. Can anyone tell me what a non-disclosure agreement is? We did discuss this yesterday, so can anyone tell me what this is? Can any one of you unmute to tell me what it is? Can anyone tell me what is a non-disclosure agreement? A very short one. We did have a in-depth discussion on the same yesterday.
It's an agreement
Three pillars.
restricting the
What
Okay, one at a time. Okay, Kavya, you can go first. Then we'll hear it first.
it's an agreement restricting the other party from disclosing what they've seen, heard, or written.
Okay, true. And Smriti, do you have something else to add on to what Kavya said?
the same? What to see, what to work, and what to hear.
It's not essentially what to say and what to work. It's essentially a record. It is essentially a document which prohibits an employee or prohibits a party from discussing what they see, what they hear, or what they do in a closed company environment. Both of you are somewhat right. I'm proud of that. Thank you. So let's discuss. This is a sample NDA. And yesterday, like I said, do you remember what is the standard clauses that you see in a commercial agreement? Any idea? Okay, fine.
So some key
So in a
principles you were given.
yeah. Can you reiterate what they were? If you can remember, that would be nice. If not, also we'll
Clarity
go it
and
again.
precision,
Okay.
consistency,
Okay. Okay, fine. Thank you, Smriti. Thank you for replying. So if you look here, this is a standard non-disclosure agreement copy. This is usually made on the letterhead of the company that is issuing the NDA, be it company A, company B, any other company that issues an NDA. It is made on the letterhead of that particular end company. Now, the non-disclosure agreement, the starting will always talk about the date, which is one of the most important parts of a non-disclosure agreement, because the date that we mention on the agreement is from which the agreement will be effective. So we do not miss out on the date. The date has to be correct. We cross-check the date as well. Then these clause are called as the opening clauses. So these are the opening clauses where you mention company A and company B. Party one here will be company A, where you mention where they are incorporated, their official address, and you shall also say that from here on they will be called as company A, or they will be called as one particular name. Then you go to the next section, which talks about the next party. Party two, customer, anything can be used, where we'll say party two, their company where it is incorporated, their registered address. So these are essentially the starting clauses that talks about the start of that establishes the parties involved in this particular contract. Now moving forward, we will then we have the clause which mentions why this contract is getting into. So this contract here is made. So NDAs, like I said, I don't know if you guys remember, but NDAs, like I said, are made prior to a established contract. So NDAs are made to to start the discussion on a possible collaboration, or to start discussing on what we can do. So before a company reveals their secret to the other party, we sign this NDA so that we can have a free flowing exchange of talks between both the parties, without one party feeling that their secret will be out or their product will be out. So that is why here we are talking. That is why when we say that here, if you see, wish to pursue discussion, negotiate with each of for the purpose of entering into potential business arrangement in relation to, we'll talk about the transaction. Essentially, what it is, what not it is. We'll talk about why it is being made. So here, arrangement in relation to a joint venture, or in a arrangement in relation to put out a new product in the company. And then we'll have the part with the clause which talks about the transaction, how it is confidential in nature, and what is confidential, why, and what is proprietary. We'll talk about we'll say that in this discussion, the parties may exchange information, material, documents, finance, assets, operations, which will completely be called as confidential information. And these will be considered as proprietary and confidential. And then next we have each party wishes to review such confidential information of the other for the sole purpose of determining their mutual interest. So this is why, and this is the closing clause which talks about why this transaction or this confidential information is being shared by both parties. So any doubts till now? Do we have any doubts? If no doubts, a thumbs up. Okay. Perfect. Perfect. Thank you, guys. Next, is what we talk about the parties' contribution. So parties hereby agree. What are their obligations? So the parties agree here that confidential and proprietary information shall mean and include any information disclosed by one party. The party disclosing is the disclosing party, and the party who is hearing the information is the receiving party. Please remember these two words: disclosing party, receiving party. These are two important words in a non-disclosure agreement. And then we have the list of items that they include in writing or by inspection of tangible objects, which and include without limitation any material, trade secret, network information, all these things that we will be listing them down. Then we'll talk about what is the receiving party not allowed to do. So the receiving party will be not allowed for disclosing, reproducing, summarizing, or distributing the confidential information that you get from the other party, except for this particular transaction. So, for example, if you are building a new mobile phone, then for the purpose of building this new mobile phone, the confidential information can be shared between each other for the benefit of this particular transaction. But apart from that, the parties will not be allowed to change. Then we have the parties shall protect the confidentiality of each other's confidential information in the same manner as they protect the confidentiality of their own proprietary confidential information of similar nature. So this is where we talk about how both parties should have the highest integrity to protect confidential information of one other party. So it shows that it essentially says that you will have to protect the other person's confidential information, like how you would protect your own confidential information. Then we have once more reiterating fact that the confidential information shared will remain the property of the disclosing party, and it cannot be copied or reproduced without the disclosing party's prior written consent. Now, this is a very important clause which talks about the destruction of a confidential information once it's shared. Now, if a confidential information is shared between two parties, then then the disclosing party has the right to ask the receiving party to destroy the information that they have with them. So within 7 days of a written request by the disclosing party, the receiving party has to destroy all originals, copies, reproduction, summaries of the confidential information. And then they also have to submit a certified writing that says that they have satisfied and destroyed everything that they have with them. The 7 days is a standard time period that is used in the industry, but it is not a very rigid time period. It depends on contract to contract. Contracts keep on changing. Some have 10 days, some have 5 days, some have 3 days. But the standard operation is that 7, because it's considered to be a reasonable time. If not, it is up to the parties to negotiate and come to a common ground. Then this is what the obligations or duties of a receiving party should be. The receiving party can only disclose the confidential information only to the receiving party's employees and consultants on a need-to-know basis. Now, what is need-to-know basis? Need-to-know basis is a concept where you compartmentalize information and give it out only when they need it. You do not give out the complete information in one go. You tell people who require to work on it rather than giving it a company-wide, giving it a message to the entire company. You only tell employees or consultants who work on this particular project. Then the receiving party shall also execute appropriate written agreements with third parties in the former. So then if the receiving party is hiring someone else to work on this particular project, then the receiving party should get into another NDA with that third party vendor to make sure that the information that they process is not disclosed or misused in any other way. Then we have what is not confidential information. Till here, is everyone clear? Any doubts? Any doubts? If not, you can give a thumbs up. Guys, so confidential information, this clause particularly talks about what will not be considered as a confidential information. So you will so any public domain will any public domain data will not be considered as confidential information. The information that is already possessed, that is already with the is in the possession of the receiving party will not be considered as confidential information. Anything that is independently developed by the receiving party without using the confidential information will also be not considered as a confidential information. Then if you have something which says that if you have a written authorization from the disclosing party for release or use, then that particular thing will not be considered as a confidential information. So this is a very common clause in the industry that is always there, so that we have a clear distinction of what is a confidential information and what is not a confidential information. Anything that does not fall within this 1, 2, 3, 4 aspects will be considered as a confidential information, and the parties will negotiate on it if on a need to know, on a need to do basis, if and when the situation arises. So this is what happens during. So this part happens. This clause talks about a situation where if a judicial commission or a judicially body like a high court or a state court or a district court or a supreme court ask the party, receiving party, to disclose the confidential information, then the receiving party should first inform the disclosing party that he or she has received this particular request from the court. Then the receiving party can only disclose the confidential information to the extent for which it is required by the law. It cannot go beyond what is required by law. If the law says tell us about this particular aspect only, you're only allowed to disclose what is there according to the law. You're not supposed to disclose about the financials or any other thing. So if the warrant or the summons ask you to disclose about XYZ, then you're only allowed to disclose about XYZ. You cannot disclose about ABC. So that is where this particular part comes up. Then we have the next clause which talks about trademarks, proprietary words, simple. So this essentially prohibits both the parties, both disclosing and receiving party, to use the others names, other party ka name, templates, trademarks, words, or symbols in any publication, press release, or marketing material without the prior written approval of the other party. So this essentially prohibits an infringement of copyright by both parties without permission. See, this is again, and this is the next clause which talks about, like I mentioned earlier, that the condition in this agreement and the confidential information disclosed to this agreement are special, unique, and extraordinary character. So there cannot, it is for this particular injury or this particular, so these information that is being disclosed is only for this particular transaction, and it cannot be used for anything else. So this talks about the indemnification part. where the receiving party shall indemnify the disclosing party of all costs, expenses, or damages that disclosing party incurs as a result of any violation. So this will include court fees, litigation expense, reasonable attorney fees. So it talks about the damages in case of a remedy of any breach under this agreement. So when there is when there is a breach under this agreement, the non-breaching party is entitled to seek specific performance. Now, can anyone tell me what is indemnification or indemnify? Have you guys heard this term indemnification or indemnify anywhere?
Make good of the loss.
Hmm, okay. Any other definition? Do you have any other definition? Compensation for a loss. Okay, Harshita. Any other notes? Anything else? Okay. So indemnify is nothing but it essentially says it is essentially to pay or promise to pay someone an amount of money if they suffer a damage or loss. So this clause essentially talks about damages. If there's particular damages, then if there is any issues between two parties, if there's a breach, how do we handle it? That's the part that talks about it. Then see, now this is a very important clause. It allows both the parties. Wait, I'll keep it here so that you guys can read it. Yeah. So this is a very important clause which says that both the parties entering into this contract has no obligation to disclose any or all confidential information to the other has. Oh, sorry. I'm so sorry. This clause essentially says that any parties that is there to this NDA has to disclose all the information, confidential information, as and when required for the facilitation of this particular transaction. And also the parties will also have the right to disclose only information at its discretion and which it thinks is necessary. So it gives a power to the company, to both the parties essentially, to disclose necessary information only and also to prohibit leaking of unnecessary confidential information. Then we have the next clause, which is very important. This says that this agreement will be effective from the date of execution of this agreement by both the parties and shall continue to effective till the proposed transaction is terminated by either the party by giving a 30 days notice. So this is called a notice period clause. Essentially, they talk about termination and also the effective date. Now we discuss about the effective date. Now there are two parts of an effective date. One is either this date the agreement is made on, or the next part will be the signature date. The last date that has been this contract been signed. So that depends on the contract, from contract to contract, company to company. They keep on changing which date is important and which date is not important. So that is the execution effective date. And then we have the notice period of 30 days. Now 30 days notice period is standard in the industry. We do have contracts where there's 20 days. We do have contracts where there's 45 days of notice. We do have contracts where there's 60 days of notice. But in the industry, it is standard to keep a 30 days because it gives a good buffer time for the parties to negotiate or reiterate what they have to do or what they not to have. Then we have the clause, like I said, talks about invalid or unforeseeable, where the agreement. So this goes down. I don't know if you guys know about the concept of where in a contract there's the legal maxima which allows you to cut out the bad parts of a contract and then enforce it. So this essentially is a clause that reiterates the same thing, which says that if there is anything invalid or unforeseeable to the extent the remainder of this agreement shall not be affected, and each and every provision will be valid and enforceable to the fullest extent permitted by the law. So if there is any invalid or unforeseeable provision, then that particular clause alone will be changed, and that particular clause alone will be removed from the main contract, and the contract will go ahead as it is like normal. Then the last clause here, yeah, yeah, by the
So very sorry to interrupt you in between, but I'll have to leave due to
Yeah.
some emergency. But Harsh sir will be there to assist you as a moderator if you need anything. Thank you so much, and very sorry to leave in between.
Yeah, no issues. Thank you, Eddie. I hope everything is okay with you. So the last clause here is the I don't know if you guys remember the judicial clause, the jurisdictional clause, as well as the arbitration clause, dispute resolution clause. We discussed this yesterday. Can anyone explain to me what this highlighted clause talks about? Clause number 90. Do we have, can someone volunteer to explain or give a short example or short explanation for clause number 19? Because we discussed this yesterday. Do we have any volunteers? Okay, so this is a clause that we discussed yesterday that talks about the governing law for this particular contract. And we also talk about how the particular, if there's a dispute, then how do we resolve it? So in this clause 19, you can see that the contract agreement is governed by the laws of India. They are the jurisdiction will be the courts of Bangalore. Then if there is any breach, they're supposed to go for arbitration and reconciliation. Arbitration under the Indian Arbitration and Conciliation Act. So they will talk about, and then they have also mentioned that the arbitration tribunal shall be composed of a sole arbitrator, and which will be appointed mutually by both the parties. The arbitration seat will be in Bangalore. Arbitration proceedings will take place in English. So they have made it very sure that if there's a breach, this is the process we have to do. Exactly. Good. Good, Dhanashri. Then they also talk about additional oral agreements do not exist. So if there is a future modification to this NDA, it should be made in writing, attached as an amendment. We cannot just call up the other party and be like, hey, I want to change this. So he will be like, okay, go ahead, change. This oral agreement is not considered valid for this agreement because it's particularly written like that. It's particularly, we have a clause included for that particular aspect, so that won't be happening. Then with that, we have come to an NDA in, and this is where both the signatures of both the parties sign. It's not compulsory to have two signatures. It's not compulsory for one party to have two signatures. It could be one signature each. It could be one signature each plus two witnesses. It all depends on from company to company how it goes, the value of the transaction, the people involved. So there's no standard set, but this is the standard format that normally the industry follows. So with that, we have come to the end of an NDA. Any questions, any doubts? I would like to take that on NDA before we go on to the next one. Anything, any doubts?
Sir, you've mentioned about a clause wherein any provision can be changed if it is not in consonance with the law. you gave a title to it. Could you repeat that title?
Sorry, I didn't get your question actually.
Just before coming on to clause 19, you've
Yeah.
mentioned about a clause wherein any provision can be changed so as to make it enforceable.
Yeah, essentially invalid clauses. So a contract may you are allowed to cut out the invalid parts. You are allowed to cut out the you are allowed to make amendments to remove the invalid part so that the contract can go ahead without acting on it. Is that what you meant?
Yes, sir. Yes, sir. Got it. Okay, thank you.
No issues. Perfect. Any other doubts on NDAs? So could you highlight the various confidentiality obligations other than non-disclosure and post-employment period for this NDA? Highlight various other confidentiality obligations. I didn't get your question. Like when you say various other confidentiality obligations uh, for a employment contract, are you asking, or for this particular NDA, are you asking the question? Tanushree? What can be the obligations? So obligations again it differs from one particular contract to another. The standard ones are the ones that we discussed, which you could see as common in almost 80% of the contracts. There the that is the non-disclosure part, employment period, how to handle it. These are the obligations. Essentially, in an NDA, the main obligation or the main task for both the parties, that is the receiving party as well as the disclosing party, is to keep the confidential information safe, to only disclose them on a need to know basis, to only use them on a need to know basis, to only work on it when it is required, and also to make sure that you safeguard it as you would safeguard your own confidential information. So this is the standard normal clause that you see in an NDA. But apart from that, some companies or some other particular instances, depending upon the nature of the transaction, we do get more obligations added. Like if it's a financial agreement, or if it's a monetary transaction that is being involved, then they will be talking about how the finance is handled, how the disclosure of finances, money laundering, transactional monitoring will come into an obligation. So it depends upon how each and every transaction or each and every commercial transaction is happening. So it differs from contract to contract. I hope I made sense to what your question was. Okay, perfect. Perfect, Lakshmi. Any other question, any other doubts do we have? Sir, if anyone breaches this agreement, then any kind of penalty or punishment clause where there. So that's what, if there is a breach of this agreement, we did have a clause that talks about damages, where the party that is breaching the contract will be the one liable to pay for the damages. At the same time, we do have an arbitration clause also. So we'll go for arbitration if there is any breach of agreement, and then we will be bounded by the decision that the sole arbitrator will give. In the standard contract, this is how it is. But again, like I said, from one transaction to other, there will be penalty clauses involved, or there will be damage clauses involved, where some NDAs might have a damage, or will have a fixed amount as a damage. Some will have a rolling damage, where it will depend upon the nature of the damage that happened. So that differs from contract to contract, but on a standard basis, the breaching party will be liable for the damage and will go for arbitration. I hope that clears your question. Okay, thank you, Smriti. Any other question do we have? If not, I'll quickly open the next one I had in my mind. So the next one that we can discuss with me today, right now, that I have is a service line agreement. Once I'll just quickly show my screen. Is my screen visible to everyone? A quick thumbs up or yeah, perfect. So this is a service line agreement, service level agreement. This is usually again, this is done on the header of the company which is giving out this agreement, and we do work on it. We do work on it from a need to know basis again. Can anyone tell me what is a service level agreement? We discussed this yesterday. So if anyone remembers, could someone just tell me what is a service level agreement? A quick definition. What do you remember? You do not have to be very precise. Even if you're wrong, also I don't mind. Like I always say, participation is the best result. I would I would have I would be very much happy that you participate. If you guys participate more than, even if you guys don't let out, even if you give out the wrong answer, also I don't mind. But I would like to have a participation, guys. So if you guys can tell me quickly what does service level agreement means, because we did discuss this yesterday. Anyone remember? Anyone? Okay, fine. So service level agreement is essentially, like I said yesterday, service level agreement are between two parties where there is a offering for a service to be done. Now I give the example of Legal Lock and myself. Legal Lock and I got into a service level agreement where Legal Lock is taking my services as a instructor, as an expert in commercial agreements. Legal Lock is getting my services for which I will be having a certain consideration for this. So that is a service level agreement. Again, this is a standard template of a service level agreement where it is for the National Internet Exchange. It's a fictional standard. It's a fictional agreement. Do not look at the companies or anything. I just quickly wrapped something up so that I can show you guys how it is. So again, the execution date is very important in a service level agreement. It's similar to an NDA. We do require the execution date because the agreement will be enforceable from the date of the from the date that is mentioned in this particular agreement. So anything that you do before the agreement is signed, or anything that you do before the agreement is signed is not considered valid. The other party is not liable to pay you for it, and you are doing it on your own, and it will not be bound under the service level agreement. That is why the date is very important. Then, like similarly, we have the introductory clauses for the both parties, where we mention who is the customer and who is the service provider. So, a very common example of a service level agreement will be your agreement that you sign when you take a Wi-Fi from a network provider, or when you take a cable TV connection, or when you take a landline connection. You would have your parents, or you would have signed a service level agreement between the parties to provide one service for this much amount. So that is a very common example. Think on it. You do knowingly or unknowingly might have signed a different level of service level agreement every time that you've taken a service in a formal way. You would have signed one if you have this SIM card that on your phone that you're using on your own. If the SIM card is in your name, you would have signed a service level agreement for that. If not, every service level agreement needs to be as 12 pages or 10 pages. It could be 1 page. It could even be 10 sentences also. As long as it is bindable, as long as it is enforceable and within the level of law, it is considered to be valid. So here, They talk about who the customer is, who the service provider is. Then they talk about the service provider's expertise. Then they talk about why the customer is availing the services. Then we have the clause which talks about purchase orders, which is essentially the payment of money. Then these are all standard parties. Service provider and customer shall be referred individually as party and collectively called as parties. Now, these are the definition clauses. Like I explained to you yesterday, this is a definition clause which says that service provider and customer will be party and the collectively known as parties. So when you read out to the product, you know who is the party, who is party one, party two, who is parties. These are definition contracts. See, now you have, I took this because there is a particular definition clause. Now, does anyone remember the importance of definition clause? We did discuss the definition clause important yesterday. So if anyone remembers, you can quickly unmute and say. Anyone remember? Okay, so definition clauses are there to make sure that there's no ambiguity regarding any particular, there's no ambiguity regarding any particular terms in the contract. So that we do not have scope for a wide interpretation and everything is very clear. So if you look at here, it shows that what is the meaning of services. Services is providing the services by the service provider as agreed in the PO. So there's no other scope for interpreting services as something else. Customer area. Customer area means a rack or any service provided by the service provider to customer where the server of the service provider is located for the purpose of this providing service. So we know where is the customer, what is the customer area. You know what is the downtime. Downtime means the duration of service outage. Then you know what are the exceptions. What is exception? What is emergency maintenance? What is facility? What is fees? What is network? So these are common terms that we use, but so these terms could have multiple meanings. So instead of having a situation where the meaning between one party and the other party is different, and there's a lot of assumptions and different interpretations going, we put definition clauses so that there is no wider scope of interpretation. It is crystal clear. And if there is a conflict of interpretation, the analyst or the associate working on this contract will refer back to the definition clause to see what it is. And what it is mentioned in the definition clause will be the one that will be going forward. This is the final interpretation for the words that we see on the contract. Is it clear? Is it clear for everyone? Okay. So these are all the definitions that we have. I am just quickly going through them. Okay. Now next clause. Clause 3 is scope of services. Now, can anyone tell me why scope of services clause is very important? You guys might have seen scope of services or scope of a contract. Can anyone take a wild guess why scope of services are very important?
To be precise and to narrow down the scope.
Exactly, precise. So that is very correct. The scope of services are mentioned so that there is no difference or there is no confusion between what one party has to do and the other party does not expect more from the party which is offering the service. So scope of service will detail down, the clause will detail down everything the parties are supposed to do. Here you can see the service provider will provide the service as per the service opted by the customer. Then service provider assures that it should provide its immediate support. Services will be provided by to the customer service provider the following infrastructure. You can see dual active power, how what are the certifiable, what is a new what the neutral data set. Do not look, you don't need to look at the scientific specifications that you mentioned there, because this is a contract that essentially is for a Wi-Fi. If I remember correctly, this contract was talks about a Wi-Fi connection. So I had to remove the information, the confidential information. So I had to remove the names of parties and everything. That is why. So don't look at the details, but you can see, you get the understanding of why scope of services are. Scope of services essentially will give a very particular uh, broad set of obligations that the service provider will provide to the customer. It talks about 24-hour support. It talks about at what cooling rate it is provided, at what cooling the servers will be running. So you will have all the details. And if the service provider fails to provide something to you that they have mentioned in the scope, then it is considered to be a breach of contract. So it is very clear in the beginning itself what is the service, what are all the things the service provider can provide, and what all the customer can expect from the service provider. Anyone has any doubts on this class of service provider? Sorry, scope of services. Anyone has any doubts? Thank you. Perfect. Then we have exceptions. Now, what is exceptions? Exception clause essentially tells what all could be considered as the exception to the existing scope of services. So here you see that the following events do not constitute downtime. So you can see in the scope of services, they might have mentioned something like if there's a downtime, then they will get service credits which they can use for future free maintenance and everything. But here you can see that these events that they mentioned very clearly will not be considered as a downtime, and therefore they won't be eligible for any service credit. So this is particular for this particular contract only. But exceptions is as a broader term is a common clause in service line agreements, which talks about accepting factors where it is beyond the control of the parties, so you can handle it. Excuse me, just give me 1 second. I'm getting a very important call. Just 1 second. Yeah, I'm so sorry for the I'm so sorry for the interruption. I was getting a very important call from office. That's why. Okay, yeah, coming back. So exceptions are common where where it goes beyond the scope of your services, and you can mention where these are considered to be accepted items. Then the next clause is service credit. This is only for this particular contract. We do not have to discuss on that. Then the next clause is again confidential information and non-disclosure. So I'm pretty sure you guys would already know what is a confidential information and what you are not supposed to disclose and everything, because we just had a discussion on that. So I don't think we need to go ahead into again in depth into confidential information non-disclosure. Essentially, essentially all service agreements will have an NDA clause. Sorry, we'll have a non-disclosure clause that talks about confidential information. So even in a service level, even in a service level agreement, also we disclose certain items between the parties. We disclose uh, technical, commercial datas, um, data sets, your personal information that the company collects, All these will be considered as confidential information, and they are again have to be considered very close. They can only be disclosed for a need to know basis. They can only be used for a particular reason only. They cannot be sold. They cannot be traded. They cannot be given out to a third party without the prior written approval from the customer. These are all the confidential and non-disclosure agreement clause. Non-disclosure clause that we have. Then we have payment terms. Now, payment terms is another very important option. So here in this particular contract, they focuses on purchase order, which is called a PO. Now, what is a purchase? So most of the service level agreements, if you go in, when it goes to on a bigger scale, most companies will follow the purchase order system. Now, PO system is essentially where for each and every service, every month of invoice or a purchase order is raised by the party to the customer, and the customer will pay for it. So if you look at your, so there's two systems. One is an invoice system and the other one is a purchase order system. Now, purchase order system is raised when one party is used when one party raises a purchase order and the other party agrees to the purchase order, and then the transaction or the money is changed. An invoice is done once the service is completed and we raise an invoice and give it to the party for the payment. Purchase orders are raised before a deliverable or a particular service is completed or before they start, and invoices are raised after the service is completed. So here in this particular contract, they're going with the PO system, which is and they are going for a quarterly payment system rather than a monthly system. Then we have review procedure. Review procedure is again a very common clause that they say that every 12 months on a mutually agreed date, we will review this contract, and then we will see if there's any changes to be made. If there needs to be any revisions that needs to be corrected or changed, we'll do that.
Sir, sorry to intervene, but what
Yeah.
was PO?
PO is purchase order.
Okay, sir, got it.
Clause 9. Okay, this procedure for availing service credits is only for this particular one. We are not dealing with that. Troubleshooting and resolution times are common in the IT industry. IT industry service level agreements you will mostly see this troubleshooting and resolution times clause, which talks about how if there is an issue for the particular service that is being provided, they will troubleshoot it and then they will try to resolve the issue within this particular time, within 3 days or within 7 days or within 5 days. So for the best customer satisfaction, the resolution times will always be considered to be as low as possible. When you have a higher resolution time, when you have a very big resolution time, the problem is that the customers will be dissatisfied because we'll have to wait for a long to get the issue resolved. So majority of the companies will make sure that their resolution time is as low as possible. Here you can see that within 3 days of the within 3 days of completing within 3 days they will resolve the issue. Now, the other important common clause is again termination for a breach. If there is a breach, then neither of the parties can terminate this contract by giving a 30 days notice period. Again, like I said earlier, 30 days is standard in the industry for any type of agreements. We do have 45, 50, 60, 90 days notice and all, but that depends on the contract, that depends on how it is set and everything. But 30 days is the standard, like I said earlier. Then we do have damages. Like I said, here they're talking about service credits, but damages could be anything. It could be monetary, it could be getting the project completed on time, it could be compensation, it could be anything, but here they're talking about service credit. Then we have indemnity clause. Like I said earlier, the service provider shall keep the customer fully indemnified against all actions, claims, proceedings, cost, damages, legal cost, expenses, everything. Then notice, they have given written notice, how the format. Some contracts will have the format for a notice on it should be like this or how it should be. If there is a breach or if there's anything, the notice has to be issued in a particular format. So that format would also be given in the contract. Now, these are some of the general provisions that you see in any contract. You have severability. Severability is something that, like we discussed earlier, I don't know if you guys remember in the previous NDA, we saw no, in an agreement, if there is any one particular part of it or a clause of it which is considered invalid or unforeseeable, we will cut and remove or cut and sever that clause only, either replace it or remove it completely so that the contract can be executed fully. We do not consider the entire contract to be invalid, we just consider that one particular clause to be invalid. Then we have waivers, then we have amendments, then we have what sort of relationship it is between the parties. That service provider is engaged as an independent contractor and is not a partner or a servant or an employee of the customer. So there is no employee-employer relationship or partnership involved. It is an independent contractor. Then we have again the similar one, governing law. We can see that the government agreement shall be governed by the laws of India. Any disputes or differences relating to the agreement shall be resolved amicably. Arbitration clause, again, we have the arbitration clause. They said that the seat of arbitration shall be in New Delhi. This is this is a three-party arbitration. Sorry, this is a three-arbitrator panel. That is what they have agreed upon. The language of the arbitration, English. So very similar, very standard. You might have seen a pattern going. Now that we have gone through two agreements, you can see that there's a pattern going. And then we have the signatures of third party. With this, the service level agreement is completed. Any questions, any doubts? Any questions, any doubts? If you guys have any questions or doubts, you can raise your hands or put a message on the group. Oh wait, yeah, is this all? It is obvious that the language of the contract must be formal and easy to understand, but while drafting, how to take care of the language? Like referring to other contracts can be one, but we would suggest more. So, like I said yesterday, make sure your language that you use in a contract is clean, grammatically correct. You do not need to use it. See, now that you looked at some of the simple contracts, you don't need to have them filled with legal jargons that mostly people won't even have to understand. Make sure you use your language that you use is very easy, very simple. You can always refer to other contracts. You can refer to templates. Right now there is a trend of using ChatGPT to correct the grammar mistakes or to the uh, correct the English that we use. That is also common right now. I've seen a lot of companies, a lot of legal professionals using ChatGPT and other AI tools to fix the contract. I am someone who supports it. I have also done it. I've used AI cell to make the structure more better. But I would never suggest you guys to ask an AI to draft a contract. That will cause a lot of headaches. But you can always refer to previous contracts. That is something that I always personally do. And from a language perspective, I try to make it as simple as possible. I do not make it very complicated. But normal formal English, not the ones that we speak, the words that we use, we can add there. But for as formal as it possible can. And there's always revision for a contract. So you do not need to have your contract to be the best at the first instance itself. There will always be revisions happening. There's multiple layers of revisions happening also. So you would be good to go is what I would say. I hope I cleared it out. Yeah, any other doubts? Do we have any other doubts? Yeah, sure. I would send these templates to Legal Lock and they can share it with you. I guess they can share it with you. Do we have Harsh? Uh, do we have Harsh? I think he is the one is the moderator for today. Is the moderator here? Yeah, I will share the templates with Legal Lock and they can send it to you guys. It's perfectly fine. One second, guys.
Hello, sir.
Yeah, hello.
Yeah.
Yeah, so I was just saying that if I share these drafts with you guys, will be able to you
Yeah.
guys will be able to share it with the participants, right?
Yeah, sure, sir.
Okay, fine. After the session, I'll send it to you.
Okay, sure.
Perfect. So we do have few more. I think we have taken an NDA and an SLA. Let me see if I have one more that I can show you guys, which is very easy. 1 second. Yeah, okay. So do you guys remember? Yeah, do you guys remember You guys remember joint venture agreement? Can anyone tell me what is a joint venture agreement? We discussed this yesterday. Does anyone remember what the joint venture agreement is?
Two entities collab with each other.
Yeah, two entities collab with each other to create a third entity for a particular need only. So that is called a joint venture, and this is a joint venture agreement sample that I have with me. So you will have, so you can see here, usually a joint venture agreement, usually this is typed on a stamp paper, minimum value of 100 rupees, non-judicial stamp paper. And we will have this is usually typed on a stamp paper, and then you can see again introductory clauses here where who is the lead partner and who is the technical partner. You will mention the name of the company, son of this. So this is between two partners or two. It is between one person. It could be between one person and one company, two people, or it could be between two companies. So here, this particular template talks about one person and one company. So you can see this XYZ son of ABC is the lead partner. And then you can see that the technical partner is a company with its registered office in one place. So this is how it is. So this is the introductory clauses that we usually follow. Then you will see why this joint venture agreement is forming. Now you can see the reason for this joint venture agreement. You can see that Inland Waterways Authorities of India has invited online tenders via notice so and so. The contract for which tenders are invited shall be referred to as contract. and the parties agree to form a joint venture for the purpose of participating in this tender and executive work if successful in award of the contract. So the purpose of bidding the contract for inland waterways authority of India is why this joint venture is being created. So you understood the purpose clause. This is called as a purpose clause. These are the introductory clauses. Then you have the Article 1, which is the formation of joint venture agreement, where they'll talk about they are irrevocably constituting a joint venture for the jointly participating in the bidding process, submitting the bid and executing contract if the project is awarded. Then you have the name and address of the joint venture. Now, every joint venture will be treated as a separate legal entity. So it will have its own name, it will have its own head office. So those will be mentioned in this article. Then this is one of the most important articles in a joint venture agreement. It talks about participation. Now, participation you will see what is the first party, second party, or other parties, how many parties are there, all these parties, how much of percentage of share that they will own in the joint venture. So it could be 51-49, it could be 50-50, it could be 60-40. It depends. It all depends on the understanding between both the parties, how the funding is going on, how they're putting in efforts, and on the basis of this, we'll get to adjust. They will adjust the amounts accordingly. So this is the participation clause, which is very important. Then you have the roles and responsibility clause. Roles and responsibility clause talks about what each party will be doing in this joint venture. Now you can see that so one person will be the lead partner for this joint venture, and that person will be nominated as the partner in charge, and that person will be performing key functions of the contract management, everything else. And then they will do what is the role of the partner in charge. Then they talk about the liability in terms. So they will talk about the roles and responsibility of each party. You can see the lead partner is for financial and execution of contract. Technical partner is for technical advice and support. See? So there's a difference. So there's a very clear definition of the roles that is involved and the responsibilities that is involved. Then you have the joint venture management board. Now every one second. So joint venture management board, like I said, every joint venture will be considered as a separate legal entity. With their own address, with their own name, with their own registration. So they will have their own management board as well. That management board will be consisting of number of members that is predetermined. This is standard. It will be a 3-member board, 1-member nominated from each party. They will decide the chairman among themselves itself. So that is how the joint venture management board works. Then you have the validity of this JVA. Now, like I said, effective date will be from the date that it is signed. And then we have this joint venture will go ahead till the bidding process. And if you win the bid till the work is completed, the joint venture will go on. If you do not win the project, then and there it is done, or then and there it is terminated. You can see. This JVA will automatically stand terminated if any of the following events occur. The present joint venture does not succeed, the tender is cancelled, work is fully completed, or all the joint venture responsibilities are completed. Now, similarly, like I said, since it's a separate legal entity, it needs to have its own bank accounts opened. It needs to have its own designated amount, designated funding, designated capital, seed funding, everything. So those expenses are mentioned here. Then similarly, like always, we have the confidentiality clause. Confidentiality clause and dispute resolution clause definitions are some of the basic common clauses that you see in every other contract. Then you can see the arbitration clause, which talks about, we have already discussed this 2 times. I guess it's clear. Then we have sustainability. Now, what is sustainable? Sustainability is something which says that if me and one other person got into a JVA, joint venture, and I cannot assign my duties, or I cannot remove my interest and rights and give it to someone else without the prior written consent of the other party in the JVA. Without the other party's JVA's approval, I cannot just give my rights to someone else, and that is called assignability. And then you have signatures, and this is a very, very, very simple JVA. Normal, it's not like this all the time, but this is a very simple one that we can, or that very simple one that we can use. Any doubts that we have? If you do have any doubts, I can take it. If not, okay, then with that, I guess we are done for the day. Moderator, are you there? Harsh, are you there?
Yeah.
Yeah, so I'm done for the day, I think. Is there anything from your side?
Yeah. Okay, sure. So, guys, do you have any last questions from so you can ask right now, and I will be sending the form, so you can fill that form for the attendance, and that's it. And after, do you guys have any question? I think we are done. And on behalf of Legal Lock, I would like to thank Sir for taking his time and giving us the valuable lesson. And by concluding this, please everyone fill this form and you can leave the meeting. Thank you so much, sir.
Okay, thank you.
Yeah, welcome. You can send us the drafts and we will share it with the students.
Yeah, I have sent it to Varun. You can.
Okay, sure, sure. I will send it to him.
Okay. Yeah.
Thank you so much, sir. It was
Thank
very
you. Thank you, guys. So if you have any further doubts, you can get my email ID. You can get my email ID from the organizers. If you have any further doubts, you can reach out to me via email or LinkedIn. You can notice me on LinkedIn as well. My name is Adnan Hamid. You can see my profile on LinkedIn, and you can always reach out to me on LinkedIn. And all the best for your future. All the best for your future endeavors. And thank you, Legal Lock, for calling me. It was always a pleasure to associate with your team again and again. Thank you so much.
Yeah. Thank you so much, sir. It was really nice having you.
No issues. Thank you.
Everyone, please fill the form. It's for the attendance, and after that, you can leave the meeting.